Benchmark Brain Death Scenario, presented by Joanna Riddle. HLT 520 Legal and Ethical Principles in Healthcare. So, right now, we are looking at a real world ethical and legal dilemma often faced in hospitals. In this instance, we have a 45-year-old patient in ICU after a severe brain injury from a car accident. The patient's condition is severe, but legally he is not considered brain dead under Arizona law. The family is split, with some prioritizing the patient's presumed wishes and others concerned about motives and possible inheritance. This disagreement is causing stress and disruption for the whole ICU team, from doctors, nurses, and support staff, potentially impacting patient care. The hospital administration may need to intervene, possibly involving ethics or legal counsel to help mediate and protect both staff and patients' best interests. Following are applicable laws and regulations. Under the statute of Arizona, Determination of Death, ARS 36-3251, legal criteria for death, withdrawal of support cannot legally proceed on this basis. This law prevents premature termination of care and ensures life support is maintained until legal standards are met. Advance directives and power of attorney. These are needed to exist. That agent's authority is paramount, provided they act according to the patient's wishes or best interest. If there is no such document, the law directs care teams to the next appropriate surrogate in the statutory hierarchy. Surrogates are designated to make the best decision according to the patient's known preferences, or if unknown, to do what is in the interest of the patient. Also, allegations of family members acting out of self-interest, such as for inheritance, must be carefully investigated. If surrogates cannot agree or act appropriately, hospital policy requires convening the ethics committee. If unresolved, legal action may be necessary, and a court may be called to appoint a guardian or issue directives over the patient's care. The protection of rights. Throughout the patient's autonomy, previously expressed wishes and the best interest are the guiding principles. Laws and regulations are interpreted to prevent unilateral decision-making, protect vulnerable patients, and ensure that all care is legally and ethically justified. Interpretation of laws and regulations when making a decision. As previously stated, the legal definition of death in Arizona defines death as the irreversible cessation of all circulatory/respiratory or all brain functions. Since the patient does not meet this legal definition, withdrawing life support based solely on presumed death is not permissible, protecting the patient's legal rights until criteria are met. For the patient, if they have advanced directive, DPOA, and a POA, if the patient has one of these that is valid, that individual is legally empowered to make decisions medically on the patient's behalf when the patient is deemed incapacitated at the time. Pozarg, 2023. The DPOA/POA must act in accordance with the patient's documented wishes that are outlined in their advanced directives, DPOA, or power of attorney. If those are not known, it is best for them to act in the best interest of the patient's wishes. This existence of these documents should be verified and honored as a priority in the decision-making process. For those who do not have a DPOA or power of attorney or have no advance directive at all, Arizona law identifies the spouse or the closest next of kin as a default surrogate. Surrogates are required, just like DPOA and healthcare agents and everything like that, or power of attorneys, they are required to make those decisions aligned with the patient's prior statements, values, or if unknown, what would be in the patient's best interests. This legal framework ensures that decisions remain patient-centered and ethically sound. Pozard, 2023. Continuation of interpretation of laws and regulations when making a decision. For resolving disputes, that means when a family or surrogates disagree or if they're concerned about the conflicts of interest, if someone's just out to gain inheritance from the patient in this condition, hospital policy requires a referral to the ethics committee for mediation, in which, if consensus cannot be reached, courts may appoint a guardian or issue a decision always prioritizing the patient's rights and welfare, and as in Dresser 2023. However, if you don't document it, it never happened. Therefore, every step, including verification of the DPOA, POA, any family discussions, committee consultations, and interventions must be documented in all healthcare aspects, because if you didn't document it, it never happened. This will help ensure transparency, legal protection, and alignment with hospital and legal standards. Gedge and al. 2022. Overall, the presence of a DPOA power of attorney is vital and legally binding. Without one, state law provides a surrogate hierarchy. All actions must comply with these statutes, ethical principles, and institutional policies to safeguard the patient's rights and well-being. These on this slide are currently some of the ethical issues that, in this instance, patients, families, and the patient are often faced with. Respect for patient autonomy. A central principle in healthcare ethics is making sure you're honoring the patient's autonomy, their right to make their own medical decisions even at the end of their life. If the patient's wishes are not documented or known, such as lacking an advance directive or DPOA, it then becomes very ethically challenging to ensure decisions truly reflect their values. The administrator must balance input from the family with the committee to prioritize when what the patient would have wanted in this instance, relying on any available statements or evidence of the patient's preference. Gedge and al. 2022. Therefore, surrogates are not ethically bound to represent the patient's interest. Actually, never mind. They are ethically bound to represent the patient's interest. What am I saying? They're not to represent their own interest. When there's suspicion on the rise of personal gain, like inheritance or financial gain in general, there is an increased risk that decisions may not be made in the patient's best interest. The administrator should carefully assess whether any surrogates are acting out of self-interest, and if necessary, make sure they involve ethics or legal teams to protect that patient in the time of need, as they are not able to make decisions their own. Annas and Dresser, 2023. The following, in order for the administrator, they must maximize potential benefits while minimizing any harm. So therefore, they must weigh the benefits of a continued life-sustaining treatment against the potential for increasing suffering or poor quality of life after this patient is out of the ICU and able to make the decisions on their own. Although providing aggressive treatments with little hope of meaningful recovery can do more harm than good, conflicting with the ethical principle of do no harm. On the other hand, withdrawing or withholding care before all legal and ethical criteria are met could violate the obligation to preserve this patient's life at the age of 45. Continuing on the topic of ethical issues for this case, patient autonomy. Justice and fairness, and professional integrity and staff well-being, fidelity to instructional and social societal trust. A core ethical principle, as previously mentioned in medicine, is respecting a patient's right to make their decisions about their own care, including the right to refuse or withdraw from licensed treatments. In this scenario, determining and honoring the patient's wishes is more complicated by the lack of clear advance directives and strong family disagreement, which means the ICU staff must bring in an administrator who will be vigilant not to override autonomy. if there's any evidence of the patient's preference, even under pressure from family. Surrogates are legally and ethically obligated to act in the patient's best interest, not for personal benefit. Allegations that family members may stand to gain financial gains or anything like that, such as inheritance, will strongly raise some serious ethical concerns about potential conflicts of interest. The administrator assigned to the case must ensure that surrogates' decisions reflect the patient's values and welfare, as we have previously stated in multiple other slides in this presentation. If it is deemed that the patient's surrogate is not acting in the best interest of the patient, then counsel and ethics team will be admitted to this case to validate the surrogate's actions. Overall, for this slide, we must ensure that the administration team makes sure that they are able to help support the best interests that are legally required in the patient's case. On to our next topic of implementation of supporting policies and procedures. At the top, we have advanced directives and surrogate verification. As previously discussed in multiple of these other slides, it is very important that patients have this, or they are able to correctly identify the surrogate in advanced directives or healthcare alternatives, healthcare agents, who are able to help them. Therefore, this is a first step in ethically sound end-of-life care, is to verify whether the patient has an advanced directive, living will, or has appointed a DPOA or POA for healthcare. For this instance, in this case, the 45-year-old in the ICU due to brain trauma has not had any legal documentation of a DPOA or advanced directives. Therefore, this causes a bigger ethical issue than what it should be. Although this patient not having any advanced directives, it is in the best interest that the family and her surrogate that is assigned to their care to make the decisions on them should have made those interests in the best care of the patient. However, staff in the hospitals, especially in this case of the ICU staff, they're trained and should have a standardized checklist to confirm and validate and make sure that's applicable of these documents of what the patient should need and is wanting for their decisions. To move on, we have the policy and procedure considerations. The first one is going to be a big topic, as we previously discussed, as advanced directives such as a DPOA, POA verification. The first step in any end-of-life case is confirming whether the patient has an advanced directive, living will, or has appointed a durable power of attorney for healthcare, or power of attorney. Hospital policies should provide a standardized process for verifying these documents, validating and ensuring they are current, applicable to the present situation. As for in the hospital I work at, we have to send these documentations to our legal team and medical records, going through our legal team first and then the medical records team. If they're validated and current, then our legal team will allow medical records to ensure that they're put in the patient's chart, and then legal can ensure that the chart is updated with the correct legal guardians or power of attorney information that they need. If found that a patient has an advanced directive and a DPOA, the wishes expressed in these documentations or by the designated agent must be prioritized in all decision-making aspects. As previously mentioned, surrogate hierarchy is in the case of no advanced directive or DPOA if they're available, meaning staff must follow state law and hospital policy to identify the correct surrogate decision maker, typically starting with the spouse, then adult children, parents, and so forth. POSGAR 2023 is essential to confirm both the legal right and the willingness of the surrogate to act and ensure their decisions are guided by the best known interests of the patients. not meaning that they are in this for the financial gain or any aspect other than the patient's best interest. Then we had the ethics committee involvement. Policy should require referral to the hospital's ethics committee in cases of family disagreement, suspicion, or conflict of interest, or ambiguity regarding the patient's best interest. So call 2021. As previously mentioned, the patient's family is having a disagreement on how they should proceed with the patient's care right now on this for the 45-year-old admitted to the ICU due to a brain injury. Therefore, the Ethics Committee provides multidisciplinary input, offers mediation, helps clarify complex ethical issues. Their recommendations should be carefully documented. Like we all said in previous, the Ethics Committee is there to help make sure that the patient's family understands what the next step is ethically and making sure that they have a knowledge on what's best. The Ethics Committee is trained professionals who work within the hospital staff doing one of the harder jobs on the opposite hand of direct patient care, making sure that the patient's best wishes are accurately documented and being thought out. For those families such as this one, structured family communication is a big thing. Family meetings should follow a structured protocol, ideally led by trained facilitators, such as those part of the ethics committee or who have a background knowledge in being able to access care for the patients in the regard to their best interest. To ensure all voices are heard and information is communicated clearly and compassionately. Also, this needs to be documented in the patient's legal chart or throughout the hospital so that way they know what and how to proceed. They are going to proceed after this instance. So for conflict resolution, which is going to be on the next slide, we're going to talk about if disputes persist after ethics committee involvement, hospital policy should outline the next steps, which may include legally involving counsel or petitioning the court for a guardianship or judicial decision. Anna's and Dresser 2023. Therefore, they could be assigned a public county administrator for the time or someone outside their direct family that can make the decisions on the behalf of the patient. This will ensure that decisions are legally sound and that the patient's interests are protected when consensus cannot be reached within the families. Staff supporting and debriefing. It is very overwhelming for staff, so therefore this can cause significant stress for healthcare providers. Hospitals should have policies ensuring access psychological support, counseling, and regular debriefings. Effenstein and Al 2020. Supporting staff well-being is crucial for maintaining a resilient and ethical care team. As previously said, if it's not documented, did it actually happen, which is a big thing in the medical world. From the simple bottom line of the care team to the top providers. Every step of this process, advanced directive verification, surrogate identification, ethics consultations, communication with family, and conflict resolution must be documented in the medical record, Sabentino 2019. This will also protect the hospital legally and ethically ensure continuity of care. As for that, these are going to be the following references I have used for this presentation. Thank you.